in a lot of different ways. And they managed to do a lot of different things. For instance, they created this group called Prosecutorial Oversight. It was a tour that was designed to go around the country and talk about prosecutor accountability in the wake of Thompson versus Thomas, a case out of Louisiana where a wrongfully imprisoned fellow sued Louisiana and the DA for $14 million, and the Supreme Court said, no, prosecutor immunity lives. So we know that those folks are out there and they're going to be looking at prosecutor accountability. Why do you think prosecutor accountability and what prosecutors do is such a big issue now? Because look at the national statistics on exonerations. 35 of them have been by eyewitness. This is from their website. 17 for bad signs, only 1 for a bad defense attorney. 3 for false confessions, 2 for bad informants, 7 for government misconduct, although only 2 of those the rest were cops. 2 of them were prosecutors. So why all of a sudden, after all these years, is the prosecutor misconduct such a big one? Why is that so important today? Anyone have an idea? I got a theory. I think it's because we're pretty much done with the DNA exonerations. I mean, we've been through that whole deal, right? We've tested just about everything we can. Now you got a whole big exoneration machine that doesn't have anyone to chew on anymore. So we turn our attention to some of the lesser numbers down there. So it only kind of makes sense that sooner or later they wanted to talk about prosecutor misconduct and what prosecutors have to do with exonerations. Your association decided to study this issue. We kind of put it together a group because we were hearing so much about Charles Sebesta and Mr. Morton and these deals that we thought a lot of people needed to know. And as a profession, we needed to take a look at ourselves and make sure that we were doing the work the way we thought we should be doing it, as best we could. Maybe it was going to end up in a written document. We didn't know that it would, but it might. Just a list of the people there. The action plan was to inform ourselves and read a bunch of stuff, which is going to be important. We were going to do a lot of interviews with people, actually talk to folks who handle these cases to see what we could learn about them. We were going to have 4 meetings, and we'd send it to the full board, and we'd talk about it. And once again, we're going to have it ready for the session, which it is. We had a reading list. You know, there's a ton of stuff that people write about you and how you do your business. You probably don't have time to read it, but you ought to look sometime. We got a good reading list, like Reconceptualizing Prosecutorial Misconduct Through Moral Disengagement Theory. Yeah, that sounds like a reader, doesn't it? Yeah, this guy, a social cognitive approach. You probably don't understand many of the words there. I don't either, but you ought to read that. Improving prosecutorial decision-making through lessons of cognitive science. How about this one? Can an ethical person be an ethical prosecutor? By the way, that's Lawton Cummins. His answer to that is an emphatic no. Nobody can be an ethical prosecutor is the way he answers that. This is all in our report. You could actually go read that stuff. It's kind of interesting. There's a lot more. You could read the Masonheimer case itself. We teach that when we talk about Brady as kind of a litmus test for what can go wrong in a case if you've got a closed file policy for sure. A professor who I've met at the University of Texas wrote an article about prosecutor exceptionalism, remedial skepticism, and the legacy of Conant versus Thompson. I don't understand a word of that article, but it's something to do with being skeptical about remedies for prosecutors. And you can go to their website and look at those cases. Kind of interesting. We interviewed the judge in the Masonheimer case. We talked to, and this was important, a lot of people that were involved in Dallas when all these exonerations occurred. Because we wanted to find out, because Dallas has had a huge history, what actually happened in Dallas. And we talked to the special prosecutors in the Graves case. We wanted to find out, really, inside baseball, what was going on there, what happened. Because, you know, it's time for us to take a look, make sure we're doing our business right. First, one problem with that, though, we had to take a break when the Innocence Project on March 29th of last year dropped a report on us that said that there were 91 cases of prosecutorial misconduct in Texas between 2004 and 2008. 91 cases. Many of you were prosecuting that period of time. And you were probably thinking to yourself, really? Unbelievable. And the person out of California says it paints a bleak picture about what's going on with accountability and prosecutors. So we took a quick look at that. And you can go back and look at this stuff. It's pretty interesting reading. You might have said to yourself, 91, that sounds like an awfully high number. I'm a prosecutor. I'm not seeing that kind of activity. Well, they got a couple of interesting cases there. This one was failure to give timely notice of an enhancement. The Graves case we knew about. This one, the Munson case, was called prosecutorial misconduct because on closing argument, the prosecutor called the defendant a molester. Now understand, it was a child molestation case. And the judge declared a mistrial, saying that that was misconduct because you shouldn't have called the defendant a bad name. Thinking, really? That's misconduct? And of course, the Graves case, we knew about the Graves case. So we started looking at it. Here's what we found in short order. Look, this is a real example of what they were doing to us. They went on the internet, they typed in prosecutorial misconduct, and whatever cases they got, they had law students just write them up. All right? That's kind of in a chart. Here's a good one. Taylor versus State. This is a case where on closing argument, the prosecutor explained the punishment charge, said the defendant under this could get this under parole. No objection. He said defendant. He did not say hypothetical defendant, said defendant, but only said it once and was explaining it, no big deal. The Court of Appeals reversed this case, saying that the prosecutor erred in arguing because he said defendant instead of hypothetical defendant. That's one of the 91 cases that is included in a prosecutorial misconduct list. Okay? That's what you're being accused of. Like, really? Well, but here's the funny thing. That was a three-judge panel. Judge Charlie Baird, actually was the visiting judge on that, wrote that opinion. That opinion didn't actually survive. The Court of Criminal Appeals read it and said, no, that's ridiculous. They actually said the prosecutor didn't do anything wrong at all. But the people doing the research for the Innocence Project, they just read Charlie Baird's opinion, and they put that in their report as one of the 91. They never actually shepherdized the dang case and found out that it had been reversed. That kind of stuff happened all the time. So basically, we broke it down. Out of the 91 cases, 10 of them were federal cases. We don't care about that. That makes no difference to the Texas legislatures. We can't teach that. 11, there was no finding of error at all. 59 were minor trial errors. 11 were reversed because of prosecutor misconduct. All right, so we got 11. Let's look at those 11, shall we? But first, before we look at it, what's the definition of prosecutor misconduct? Y'all got one in your brains? Y'all know what it is? Anybody? Yeah. How about that? They wrote a report, by the way. They issued an entire study about prosecutorial misconduct without ever defining what prosecutor misconduct is. How can you write a report about something when you don't define it? And by the way, when they gave their press conference, they said, when we talk about prosecutor misconduct and error, they use the word error all the time when they gave their press conference, but all the reports talk about misconduct. So the bottom line is, we worked on a definition. See what you think of this. You know, the bottom line is we're trying to talk about intentional misconduct. We're talking about when a prosecutor deliberately does something with the intent to jack the case up. That's kind of what we're talking about here. It's maybe not a perfect definition, but this is the definition that we think the public uses. And by the way, when we talked to the media outlets who originally reported on that Innocence Project report, and we started talking to them about this, they got it right away. They felt like maybe they'd been a little misled by the media, by the Innocence Project people trying to jack up their numbers when really it wasn't near as bad as you would think. So, the bottom line is and by the way, a little, just so you know, okay, there was 11 cases, arguably, you could talk about. During that time period, you all handled over 4,300,000 cases, okay? 28,000 were jury trials, 66,000 were appealed and had post-conviction review. Out of all those opportunities to complain, there were 11 in which there were complaints. I know what you, but, you know, I know 11's bad. We can say everyone's bad, but that's not really that bad, I don't think. And here's, by the way, after we looked at 11, 4 of them were mistrials that were granted. So they called that misconduct. But then we were later allowed to retry them. Like the Monster case I told you about, the Court of Criminal Appeals looked at that and said, no, that prosecutor's argument was proper. Go back and retry it. So all those mistrials were actually, we got to go and try them. So there was really no misconduct. One of them was a Batson case. And I don't know about y'all, but, you know, Batson can be a problem, but I don't know that every time a Batson challenge is granted on a prosecutor, that's automatically misconduct. If that were the case, I don't know. So I don't know where to put that case. So the bottom line is we had a few cases left. We're going to take 2 of them out because in both of those cases, they were like 20-year-old cases in which the prosecutor had died, could not defend himself, so the Court of Criminal Appeals said, let's try that case again because nobody knows what happened anymore. So the bottom line is we're left with the same cases we knew about all along. The Cockrell case, that was a case in which Willis, that was a case out of West Texas, an arson case that ended up in actual innocence. Banks was a case out of Beaumont. Banks, by the way, it was a big bad Brady problem. Banks just pled to life in prison in October, so they resolved that thing fairly. Graves, we know about Graves and Masonheimer. Like I say, we teach a bunch about that. Bad case gone wrong out of Abilene with prosecutors at a closed file, and it got to them. So that was a problem. One question, just so you all know, people say, are you accountable? I got to tell you, I think that prosecutors are accountable. And we kind of went through this list, just so you know. State bar discipline. Y'all are subject to the state bar. Criminal prosecution. It can happen, and it has happened on more than one occasion. Removal. There have been prosecutors removed from office, threatened with it. Civil lawsuits. Y'all do get sued. Even if you got, your immunity, you get sued. Courts of inquiry. We're about to have one up in Williamson County. They call them courts of injury, actually, and there's a reason for that. Because nothing will come of the court of inquiry except a lot of injury. In contempt of court, you can be held in contempt. Have any of y'all ever been held in contempt of court? Steve, you have been at least once, I know. Okay. I was ordered to sit in court as a jail punishment once by Judge McSpadden. He was so mad. I had commented on the defendant's failure to testify, and so McSpadden made me sit there for like the whole day as punishment. So it was kind of like contempt. And ballot box. So, people lose all the time, and that's a corrective measure for the public. By the way, if you read our report, we listed those things. It's not pleasant to talk about what happens, but the truth is things do happen to prosecutors. We have 334 independently elected district and county attorneys in Texas, over 2,600 assistants. Things are going to happen. So we're going to have some people in trouble. We're going to have some people that get prosecuted. We got people a lot of people are going to get beat because of problems. And the bottom line is this. It doesn't paint a bleak picture. It paints a group of people who are dedicated, working really hard, doing a good job every day. Yeah, someone's trying to take advantage of some high publicity cases, but the truth of the matter is y'all are doing an excellent job, and we're not getting the credit for it right now. We decided to write the report, and you can go on and see it on our website. We made some key findings. Number one is, and this is important, talking points for y'all. Look, eyewitness identification remains the number one reason these cases got turned around. There are problems with eyewitness identification. We've learned about it. You all are training on it. Police officers are training on it. There's new procedures. I think we're all aware now that we've got to be careful with eyewitness identification. If there's prosecutor misconduct, yeah, most of the time, and there aren't many cases, most of the time it's something to do with Brady. But that being said, the cases that have come up in the past are just that. There are cases that largely have come up from jurisdictions that operated under closed file policies and generally weren't sharing anything with the defense. This is a big issue that we're just learning about now. The legislature is probably going to do something here and require Brady training for police officers because most of the Brady violations, it turns out, are not prosecutor violations. They are law enforcement violations. There's stuff in the law enforcement file that never got to you, and there have been some big cases that have been turned around because of that. The Williamson County case, the Morton case, will center on whether the very, very powerful and popular sheriff gave this big bad police report to the brand new district attorney, Ken Anderson, or whether Ken ever saw that report. Ken says, I don't remember ever seeing that. I know that I would have turned it over if I'd seen it, but I don't remember ever seeing that report. That's going to be it. Oh, and by the way, the sheriff is dead, so it's going to be a very interesting hearing. We found out, too, that prosecutors are probably human. Those articles about cognitive bias, I kind of made fun of it, but we're going to talk more about that in the future, and you're going to hear about it, because people can get tunnel vision. Everybody gets tunnel vision. Everybody gets something called confirmation bias, where you have an idea and you tend to look at facts that confirm that and tend to put aside facts that don't. Particularly dangerous for police officers and prosecutors. Particularly dangerous. And I'll submit to you, in some of these big bad cases, tunnel vision may have something to do with that. We need to learn about that. We need to be aware of that. There's a couple of great national speakers on it. I'm hoping at some point in time we can bring Alifair Burke to you. In the fall, she wants to come. So I'm going to try to get her. Alifair Burke is a law professor in Hofstra, was a former prosecutor in Oregon, and she kind of takes up for prosecutors on the national level. She's also a crime writer, and her father is James Lee Burke, who writes the David Robichaux novels out of Louisiana. She's a really interesting person, but she's a really good speaker, and Mike's heard her. We're going to get her here for you guys to start talking about this whole issue in the fall. State Bar, you can't learn anything then. And by the way, you guys have immunity. You know, we ask State Bar, how many prosecutors have been grieved upon? Just tell them, we don't want to know names. Just give us. They go, we don't know. How do you not know? Well, we don't know. We don't keep those kind of records. And she says, well, then how are we supposed to examine how often prosecutors are punished by the State Bar if you can't even give us the number? So, you know, for all I know, half of you guys that have grievances, nobody's allowed to know about it, you know. We don't know. Professionalism, of course. Historical context, please. This is really important for y'all. Who knows what that is? Corvair, all right. What was the book written about this? Unsafe at Any Speed. That's right. My father was career General Motors. He hates Ralph Nader to this day because Nader wrote a book condemning this car as a tremendously unsafe car. Well, you know, if a Corvair was driving around today and crashed, would we judge today's auto safety based upon the Corvair? I think not. I don't think we would. But, you know, we're judging today's based upon what happened in trials from 1983. In places where they had closed file policies and paper, there weren't computers, there was nothing. Defense is very different today. We're trying to judge, and we've got to remember when we talk to people that they're judging us upon what Charles Sebesta did in the early 80s in Burleson County. And I don't know that it's always a fair comparison. And I got to thinking about that too because I watched saw this television show about Vietnam, and they had this big story about this big battle, and everyone's fighting, and suddenly American bombers came over and they dropped a 500-pound bomb on a bunch of Americans, and they kept going. It was really bad because they killed a bunch of their own guys, and they had this big fight. I mean, wait a second. They just had a friendly fire incident and killed, and no one's talking like it's a big deal. Well, you know, when you're in the middle of a battle and it's really bad, no one's really talking about friendly fire incidents and the bad things that happen. You're kind of just fighting the war. I don't recall anyone talking about innocence in the 80s when we were prosecuting, when it was really, really bad. No one was really talking about that back then. I'm not saying that it wasn't, that we weren't careful and we tried to do right and we dismissed cases where we thought people were innocent, but we weren't shook like we were now about, we've got to be more careful about eyewitnesses and things like that. I think it was a little different world, and I think maybe a little historical perspective is important. So, bottom line is you need your immunity, and that's kind of the line for us. Your association, I know that prosecutors are going to be fighting to make sure that you maintain your immunity. You can't get sued in civil court. That really can't happen, and I know that people are going to be working hard to make sure you maintain your immunity. I don't think that's a remedy that someone's going to aim at you. But we are going to talk about a good definition. We're going to look for resources for Brady to start to bring to you so that you have from the NAPC, National Association of Prosecutor Coordinators, my group, you're going to get everything we got from the national groups that can help you on this area. We're going to help law enforcement start to talk about training for Brady for police and how that's going to work. Law schools, they don't really teach Brady in any form or fashion. When you get students, you get people come to the DA's office, they probably don't know anything about Brady. All they've learned is about zealously defending their clients. But, they got to kind of learn and figure out what it is to be a prosecutor, which is a lot different. We're going to keep talking about the cognitive bias, and we're going to keep talking to other folks about investing in your professionalism, which means the training and the support that you need. By the way, Brady needs to be taught in a new way, and we're working on it. You've got experienced elected prosecutors, like Mr. Holmes and Mike and people who have to send the message, and I think the message you're getting is a good message. But, you've got newly elected prosecutors, and they found out in Dallas this was exactly the problem they had. During the exoneration problem, they were overwhelmed with crime. Every prosecutor had this many cases. Law enforcement wasn't doing a good job of really investigating those cases. But the prosecutors were so overwhelmed that they took that case, and whatever was inside that file is what they tried. They never had the time to go outside that file and run down leads or check on stuff because they were just too busy. They tried the file in front of them and didn't ask any questions. Sound familiar? Dangerous. That's what happened in Dallas because they were just too busy and law enforcement wasn't giving them the information they needed. They were trying what was in there. The other problem they had in Dallas was that they were rotating people so quickly through cases that people would get a case where 5 or 6 different prosecutors had the case. And, you know, some of them were chief prosecutors and there were homicide detectives that looked at it and all these other really good prosecutors had it. The grand jury had indicted. Who am I, brand new prosecutor, to doubt that this is a good case because so many other really good prosecutors have already looked at this case and it's still here. It must be a good case. They weren't communicating very well about your responsibilities as a prosecutor, and a number of young prosecutors were taking cases that probably should have been better investigated and handled, and they were trying them because the expectation was they had to try those cases, because after all, lots of other good prosecutors had looked at those cases before them. So there's some real training and messages that need to get sent about how you handle your cases. A lot of that's from mid-level supervisors, the court chiefs, how they handle that, and we're going to be talking about that. Especially making sure that the new prosecutors know that it's their case, they understand their duties and responsibilities, and they have the freedom and flexibility to do what they need to do with that case, fully investigate it if they need to, or get their questions answered. What you said, your story about going and talking to Mr. Holmes about that case, exactly the kind of message that they didn't have in Dallas. In Dallas, frankly, the message was, you know, you're a weenie if you don't try these cases. They counted it. I mean, that was kind of the culture back then. They had a different culture than Harris County did, and I think it kind of bit them in the butt, frankly. Not that they're bad prosecutors. They're trying real hard, but, you know, you weren't taught to, you wouldn't have ever called Mr. Henry Wade and asked him if you could, you know, tell him you had doubts about a case. I don't think that would have happened in Dallas. And it happened in Houston, and that should tell you a lot about the quality of this office. Oh, yeah, one other thing. Non-lawyer staff and investigators. You know, one thing we forget is our investigators and your administrative staff, they know a lot about your cases and your files. And they've got a lot of information. We've launched an effort to start training investigators more and our key personnel on their duties and responsibilities because they're part of the team. You know, they hear stuff, they know things, and you got to know what they know. It's really important. So opening those lines of communication is going to be very important. Is training the answer? Senator Duncan's staffer asked me that, hey, you think training would be good? And I said, yeah, I think we can do a lot with training. I mean, I'm not going to volunteer to punish prosecutors, but I think we can do a lot with training. This is Air France. This is that airplane that about 4 years ago was flying from Brazil to Paris, flight 447, when the engines shut off the engines were working fine, but the autopilot shut off at 35,000 feet. And the pilots crashed the airplane into the ocean, inexplicably. They didn't know what to do. It turns out that they weren't trained on what happens when the autopilot shuts off because of icing on the wings at 35,000 feet. The airplane had gotten so complicated. It used to be that pilots flew airplanes with the assistance of computers. Today, the computer flies the airplane with the assistance of the pilot. And the training had not caught up with that. The training didn't manage that. The pilot's last words in the black box were, I can't believe we're crashing this airplane. Because they weren't trained on it. So the public was demanding that there be all sorts of penalties in France, and they were all looking at that. The industry said, wait a second. We can fix this with training. Everyone's trying to do a good job here. We need to look at training. So I think when we talk about crashing airplanes, we talk about convictions that turn out to be bad, I think a lot of times we can train around that. We put out our report. I thought it was pretty well received. You can see it on our internet website, tbca.com. You can look at all the documents. Got a whole bunch. The essential pieces. There's a bunch of press releases and little stuff that you can read. The Innocence Project people were really chaffed at us, by the way. They were really upset. They said that, you know, wait a second. They said, well, we are puzzled that the District and County Attorneys Association felt the need to disparage our work, especially given the fact that we took pains to acknowledge the limitations within our research. No, they didn't. They didn't say they were sloppy and terrible. So I thought that was pretty funny. But They did 2 more tour stops after Texas, and in both tour stops, they're now talking about prosecutor error and misconduct. They've inserted the word error everywhere. They've quit talking about prosecutor misconduct. So you'll learn something. I love this clip. Is the Innocence Project a paper tiger? I think maybe they are. This is a bully, and the little guy's the bully. Oh, we got some sound. Bully happy endings, you know. I think maybe the Innocence Project, you know, was acting a bit like a bully, and I kind of feel like maybe we slammed them a little bit because they've kind of gone away. We haven't heard much about that. At least if they do come back, at least let's talk about the 6 cases we really care about. Okay, let's just not make this stuff up as we go, and that's our point. Mr. Morton's response. This is very interesting. By the way, we sent him an advanced copy of our report. Mr. Morton has moved to Longview. He is not in Austin. He is living a quiet life. He has hired lobbyists to be at the Capitol. That, by the way, is going to be a good thing. He has said early on, he goes, look, I'm living in Longview for a reason. He doesn't want to be used by Innocence Project and other people that might want to use him as a front guy for their agendas. He wants his own agenda, and he does have an agenda. He wants to change some things. What he said is, look, and I love this, he applauded the association's report, Michael Morton. He says he liked it. It's a good starting point. He wants some accountability, Shannon Edmonds in my office is our government affairs director. He actually met with Mr. Morton and Thomas Ratliff, his lobbyist, for a while, and they talked about stuff, and Mr. Morton's going to be keeping in touch with us. And he said, look, I like prosecutors. Remember, I was in the pen for 25 years with a lot of really bad guys. I know that you guys need to do a good job. You just need to not put me in there, which is, you know, kind of a reasonable request, actually, you know. So he really, you know, he's a pretty good guy, and he says, you know, I want to make sure the State Bar can do it if the prosecutor's really gone bad. I want to make sure there's some reasonable things, but I don't want to make it hard for everybody else. He goes, I want to make some changes in discovery to make sure that kind of discovery stuff doesn't happen again. So I don't know. So far, that sounds pretty reasonable to me. By the way, Mr. Morton will probably be a keynote speaker at our annual conference next year. We wanted to invite him, actually, to talk to us. We can't do it until this deal is done, this court inquiry is done. But I think there's a time and a place for him to come and talk to y'all. So he'll probably be there. What can you do? You got to talk to your animal clubs and people, you know, when they start talking about prosecutor misconduct. I know everyone's busy, but if you hear things about that, you can do that. Here's a problem. This is the problem I get all the time. What about Charles Sylvester? What about Napalm Charlie? Even if one bad prosecutor is too much and we need to punish that guy. I don't know. I'm afraid I got nothing there. Maybe you guys got something that works. But Charles Sylvester is a hard-headed guy. There's a reason his name was Napalm Charlie. I think he had tunnel vision really bad. Charles thought Anthony Graves did. Charles, well, you can go on the web. He still does. And he spits bullet about what Kelly Seeger says about him. He says, no, that guy's good for it, and I still believe he did it, and I'll go to my grave thinking he did it. Charles had if nothing else, a big bad case of tunnel vision. I don't know what you do about a guy like that. The State Bar took a shot at him and missed because statute of limitations is run. Do you exchange statute of limitations for bar grievances? I don't know. Something is going to happen though, because unfortunately, as good as we all can do, someone's still going to say, but what are you going to do about Charles Sylvester? And right now, I got to tell you, I don't have an easy answer for that. I really don't.
Well, Ron?
Yeah.
What are some of the plans that the legislature do about that? Any bills yet? Or anything?
Yes. The first bill I found to do something about that was filed by Harold Dutton in Houston. His bill, official oppression, in theory, already applies to Brady violations. Think about it. You could today be prosecuted if you knowingly deny someone's right, that is the right to, constitutional right to get exculpatory evidence on the Supreme Court. If you deny a person that right intentionally or knowingly, that's a Class A misdemeanor, right? I don't know that anyone's ever been prosecuted for it, but in theory you could be prosecuted already for official oppression. Mr. Dutton's bill, number 1, makes that a third-degree felony if it's a Brady violation. And number 2, removes any statute of limitations. So there's no statute of limitations for a Brady violation ever under that bill. So, yeah, how do you feel, Mike, now? What? It's the same as murder. Yeah, a Brady violation would be on par with murder when it comes to a statute of limitation. There's more than one prosecutor who has a problem with that for a lot of different reasons. I don't know if that bill's going to go anywhere. It'll get a hearing, probably. But I don't know that it makes it. But that's the kind of thing we're going to talk about. I was in Senator Whitmire's office just to say hello a couple weeks ago, and he yelled at me like for half an hour about John Bradley. Yeah, what are you going to do about Bradley? Bradley didn't do anything illegal or unethical, and I'm still getting yelled at about Bradley. I'm sorry the guy's kind of a butthead, but he didn't do anything illegal. He's a friend of mine, I can say that. All right, now, let's go back to my original analogy, because I really want to wrap this up and bring it around, because I really do think that it shows the difference between what we do every day as a prosecutor and what everybody else does and what everybody else thinks. And that's kind of what makes you all so special. Prosecutor exceptionalism really does mean something to me. And it is different. And it takes education, because a lot of people just think you're a lawyer out there trying to win cases. They really don't understand. And largely because they've been taught that if you can get away with it, you're supposed to. That's kind of our culture. If you can get away with it, you're supposed to. And that's kind of what everybody thinks everybody else does. And that's the problem you face as a prosecutor, because you know that's not it. Y'all know who that guy is? You probably wouldn't. He's Lance Armstrong's lawyer. Isn't he a great guy? He's a guy who works in a law firm whose job it is to sue people who tell the truth and beat them into submission. And by the way, he's done it in a bunch of different cases. I just wanted to look and find out who this guy was, who was basically Lance Armstrong's attack dog in all these attacks on people who turns out were telling the truth. So that guy has a great job, huh? Yeah, do you really want to be that guy? I don't know. Y'all know who this guy is? What's his name? Yeah, most of y'all don't know, do you? There's a reason you don't know him. Do you know he is America's first and only all-around men's gold medal winner in gymnastics? My God, I mean, that's huge. America's never won that. We've never won the gold, but you don't know it, do you? Why not? Well, that picture was taken when it was in Athens in like 1994, I guess. He was 12th in the all-around going into this deal. He had fallen butt first onto the scoring table in the earlier round. I mean, it was really a disaster. But out of nowhere, he does these amazing routines. These are just really great. And so it's by a razor-thin margin. They score this deal up, and there's other Korean guys doing really good. These 2 Korean guys finish right there, and they get him up in the stand, and just as they're giving him the medal, somebody goes, well, wait a second, there's been a scoring mistake. You actually didn't win by 12/100ths. You actually came in second, and that tall Korean fella on the left, he actually won. They did a misscoring. He should have gotten the gold. So, now what do we do? So the International Gymnastics Group came to him and said, look, Mr. Ham, we got a problem here. You didn't win the gold. Really, this guy won the gold. We would think it would really be a cool thing. It would really honor sports and the profession if you would switch. What did Paul Ham say? Nah, I'm good. I'm keeping the gold. So he said, no. He said, no, I'm not. I got the gold. It's around my neck. I ain't giving it up. And maybe that's why you never heard about him. Wheaties said, Wheaties had a chance. I mean, this guy was the first ever male to win this deal from the United States. That's huge. He didn't get the Wheaties box. Some other guy in track and field who won one thing got the Wheaties box. He didn't get Wheaties. He got nothing for that. What if he had done What if he had done something different? What if he'd gone against the grain of what we've been taught in sports about win, win, win at all costs? What if he said, I'll take the silver? The guy would be a legend. The guy would be a god of sports with that silver medal. But he didn't do it. He didn't do it. He didn't take that chance. But I think you can teach it. I really do. Anyone know who this guy is? Bobby Jones. You know, golf is different than every other sport. You know, I've been putting up all these things about sports that teaches us bad lessons. Bobby Jones was a legend of the game in the 20s. And he was the first person who called penalties on himself when he made mistakes. Twice in 2 major tournaments, he called penalties on himself and didn't win the tournament. And when asked about it, he said, there's only one way to play this game. Only one way. And you know, that's kind of followed down. This is Laura Inglese. She is the Oregon state champion. Well, she almost was the state champion 4 times. Last time she lost it, though, because she made a scoring mistake, and she self-reported it. This is a fellow who plays in a league out in the East Coast, and he was winning the championship, except that he played with the wrong ball the whole time. It was like the Titleist. It was the wrong version of the Titleist. He found out about it, reported it, and didn't do it. The point is, look, Bobby Jones taught that from a long time ago. He started that tradition in golf, that we play the game the right way. And I believe that you can really teach that. I believe we can teach that, and we can continue to spread that in our profession. Even if everyone else doesn't understand it because they're following the other sports traditions of get away with it if you can, we don't. I believe in this. I really believe that in Harris County, I learned from Mike, who was one of my chiefs and other people, that we follow the Billy Jack style of prosecution. I don't know if you all know this movie, but Billy Jack was a fellow who, and I believe what you do is you tell the defense, here's everything I got, here's what I'm going to do to you. Here is what I'm going to do. Stop me if you can, which I believe is the Billy Jack style of prosecution. That's our obligation, and I think that you can teach this.
Know something? There's not a damn thing you're going to be able to do about it.
See, I think that's perfect, right? I mean, that's exactly right. That is our style. You want to see the end, don't you? That's kind of satisfying. Look, but that should be our style of prosecution. We should be telling people, and I think that that's the culture in this office, is we're going to tell you what we got. Here's what we got. Here's what I'm going to do. If you can stop me, be my guest. That's the culture that I think has been trained in this office and continues to be. And it came from this guy, and you heard him earlier today, and I think it'll be carried on. Pedro, Oregon, where we leave off. All right, he was dead on the floor with 12 bullets in his back. Officers were all in the grand jury. The Hispanic community was like, okay, something big better happen here. We better see this deal. We better see some justice here. So they go into the grand jury and they come out with an indictment. Well, one indictment, as I recall, Ed, it was one of the officers got indicted for criminal trespass, I believe. Class A or B? Class A. See, there you go. No build on all the murder cases. I mean, wow. You could see the city. You could see Houston going up in flames over this one, right? So they call Mr. Holmes. They want to have his comment on this. You know, what's the district attorney say about this deal that can calm the public and make sure the city doesn't burn that night? What is he going to say? You got to be kidding me. He said that? Really? You can even listen to him say, well, it's okay to kill him dead, it's okay to kill him dead, dead, dead. Well, what the heck? Who would say that, you know, to a mob of people? A guy got shot in the back 12 times by cops who shouldn't have ever been there. Why did they no bill it? Easy question, right? You couldn't try it for murder. It was a self-defense deal. The officer had heard a shot, right? Well, the shot was fired by the other officer. The second officer in line, when the first officer said gun, shoots the first officer in the back with his gun. So the shot that was fired came from the officers, but all the officers thought they were being fired on, and of course, if they're being fired on, they get self-defense. really bad circumstance, but the truth of the matter is we weren't convicting anyone for murder in that case. And Mr. Holmes is exactly legally right. But wow, how is it that you could get away with saying something like that? I'm going to tell you all right now, if you're a younger prosecutor, don't try that. But look, Holmes could do it. And he could do it because he was unfailingly honest. Yeah, he was gruff. He never talked to national media, but he was honest with the public. He knew his business. He had that reputation for being fair to everybody. And I think what happened after he said that was the public kind of went, well, yeah, I guess you're right, Mr. Holmes. You know, and that was kind of the end of it. And he could get away with that because of his reputation. And I encourage you to think about that as you grow in your careers as to what kind of reputation you want to have. Because I think the leadership from this office, as long as I've been here and seen it, has been in that direction. To be able to end your career and have that kind of credibility that in a clutch, you could say something like that and the public trusts you is important. Well, heck, you know, one time he ran for district attorney. I forget which one of his many times. This was the endorsement in the Chronicle. That's what they just put a picture of a handlebar mustache. And everybody knew who it was. They knew who to vote for, you know. All right. This is my guy. This is Alvin Richard. I convicted Alvin Richard in the late 80s of sexual assault. It was an easy case because Alvin Richard had a whole bunch of priors, not really violent priors, but a bunch of drug stuff and all that. So the girl had been kidnapped, dragged into a bad drug house, brutal rape. So it was an easy case. He couldn't take the stand. She saw this guy, she saw Alvin on the street corner 8 months later and said, there's the guy who raped me. And the officers arrest him. I get a report from the lab that says that Alvin Richard is a non-secretor, and the person who raped her was a non-secretor, and 1 in 5 chance that a male is a non-secretor. So I had her eyewitness, and I had 1 in 5 chance. What does that add up to? That adds up to life in prison, doesn't it? And it sure did. Only the lab test was completely jacked up. And Baldwin, I know you've worked on that case for a while, but I got a call about 4 years ago saying, hey, we're letting this guy out because the lab test that you thought was a good lab test, it weren't right. So he's out now. The good news about this deal, I mean, and let me tell you, you know, some of you all have had that, and you may have it in your career. It's not fun. It feels really bad. But, you know, he didn't hold it against me. I'll say that. First of all, he said that, you know, maybe it saved my life because I was such a bad druggie. If I hadn't gone to prison, I would have died on the street. I'm going, okay, that's something. But, you know, but here's the deal. You know, if my nickname had been Napalm Charlie, all right, if my nickname had been like Killer Kepple or something really bad, I don't know how that would have been treated. You know, the media called when they found out that I was the director of the DA's Association and one of my guys was being released for a wrongful conviction. They sniffed around that and they called around and were asking about that deal. They never wrote a story about it. They never said Kepple has a guy that has been released who was wrongfully convicted. I'm not saying that, you know, that maybe it was just boring, but what I'm thinking to myself is I didn't have a reputation for being a Napalm Charlie. You know, when Napalm Charlie got in trouble, there wasn't anyone who was going to be a friend of his. When people said, man, that, you know, there's a Brady violation, everybody said, well, you know, we always kind of thought that about that guy. His reputation kind of preceded him. When it came time for him to have friends, he didn't have any. He didn't have them. John Bradley is a good friend of mine. But John's a hard guy to work with sometimes. John was out there. John went 100 miles an hour. When it came time for friends, he didn't do anything wrong. Man, people chewed him up because he had been so hard charging. Because they had closed file policies, because they've really, really been hard on people. So what I'm trying to say is that I think if you try your case in the mold of John Holmes, if you try your case and you handle your cases in that open, honest, and straightforward fashion, that you can have that kind of reputation, that if you need to say what John Holmes said to the public, you can say it, and they'll trust you and believe it. And I think everyone here is well on the path to doing that. That's the mold, I think, of Texas prosecution. I'm proud that it's the way this office has gone. We're going to have bumps in the road. We're going to have these arguments about Brady. We're going to have to look at it. But I'm confident with the way y'all are doing your work that y'all are going to still be this person. You are going to continue to be Mr. District Attorney. you're going to continue to be, you know, a superhero to the public. Because, you know, superheroes, all they do is take whatever gifts they got and use it for the public good. That's all you're doing. You are all superheroes, and I'm proud that I can continue to serve you, and I'm looking forward to doing it for the next few years. Thank you very much. I really appreciate it.
Okay, just make sure you fill out the evaluation. You get the class on not on Tuesday, but Thursdays, 2 to 4. For most of you, you'll get an email about it. But if you can drop